In 2021, a 22-year-old man named Usman was arrested in Kano. He had 2 bottles of beer. He was taken to a Sharia court, sentenced to public flogging, and the sentence was carried out in a market square. People watched. Someone filmed it. That same year, in that same city of Kano, a property developer with documented links to 3 state government contracts defrauded hundreds of low-income families of their life savings. His case was referred to a civil court. It has not concluded. He has not been flogged. He has not spent a single night in prison. 2 men, 1 city, 1 law. So why did only one of them bleed? That is the question this video is going to answer. And I promise you, by the time we're done, you will never look at the Sharia debate in northern Nigeria the same way again. Before we go deeper, if you're just finding Naijanewsfeed, welcome. This channel exists to break down what's really happening in Nigerian politics without the noise, without the spin. Hit subscribe and stay with me because this one gets interesting. To understand what's happening today, I need to take you back, not to 1999, which is where most people start this story, but further, much further. Because the selective enforcement of Sharia in northern Nigeria didn't begin with democracy. It began with a class structure that is centuries old. Before British colonization, northern Nigeria was governed by the Sokoto Caliphate, one of the largest Islamic empires in African history, established by Usman Dan Fodio in 1804. Dan Fodio himself was a reformer. His entire movement was built on a critique of the Hausa ruling class, who he accused of, and I want you to remember this phrase, of using Islamic language to protect their own power while the poor suffered. 200 years later, same critique, different rulers. When the 12 northern states began implementing Sharia criminal law between 1999 and 2002, the public story was religious revival. The private story, the one playing out in government houses, in emirate palaces, in political back rooms, was about something else entirely. Here's what triggered this video right now. In the past 18 months, a series of Sharia flogging sentences have gone viral across Nigerian social media. Young men flogged for drinking, a woman sentenced for alleged adultery, a teenage boy flogged for petty theft in a market. Every clip follows the same pattern. The person being punished is visibly poor, visibly young, visibly without connections. At the same time, and I want you to hold these 2 facts in your head simultaneously, Kano State alone has over 40 ongoing court cases involving government contractors accused of fraud worth billions of naira. Not one of those cases has been heard in a Sharia court. Every single one is in a civil court, moving at the pace that Nigerian civil courts move, which is to say, barely at all. That contrast is not an accident. That contrast is the system working exactly as designed. Now, before I show you who designed it and why, I need to show you how it's built, because the legal architecture of Sharia in northern Nigeria has a gap in it that is so obvious, so deliberate, that once you see it, you cannot unsee it. Here's how the system actually works, and where the class filter is built into the machinery itself. Every Sharia state has a dual court structure. You have the regular magistrate courts and high courts, which handle civil matters, commercial disputes, and serious criminal cases under Nigerian federal law. And you have the Sharia courts, presided over by judges called alkalis, which handle matters governed by Islamic law. Now, here is the first critical fact. The crimes that carry physical punishment under Sharia, hudud offenses, require an extremely high evidentiary standard. In classical Islamic jurisprudence, a conviction for adultery, for example, requires 4 credible witnesses to the act itself. The evidentiary bar for theft requiring amputation is similarly high. So how is it that poor young men are being flogged regularly while wealthy men walk free, even when their crimes are visible and documented? Because the evidentiary bar is applied selectively. When a poor man is found with alcohol in a roadside shop, the arresting officer is the witness, the alkali is satisfied, sentence is passed. When a wealthy man's behavior is questioned, suddenly the evidentiary requirements become very rigorous indeed. Witnesses become unavailable, jurisdiction becomes unclear, cases get referred elsewhere. The second structural fact: alkalis are appointed by state governors. They are not independent. Their salaries are paid by the state government. Their continued appointments depend on the political goodwill of the executive. This is not a judiciary, it is an administrative arm of the governorship dressed in judicial robes. The third structural fact, and this is the one that makes the whole thing legally indefensible: wealthy defendants in Sharia states routinely have their cases moved to civil courts through a process called jurisdiction transfer. All you need is a lawyer who knows the procedure and a judge who is willing to find that the matter is better handled under civil law. Poor defendants in Sharia courts do not have lawyers.
Let me be direct with you about something before we go further. A lot of the commentary you'll find on Sharia in northern Nigeria focuses on religion, on culture, on the Islam versus secularism debate. And those are real conversations. But this video is not primarily about religion. It is about a political machine and how that machine uses religion as fuel. Let's start with the governors. When Ahmed Sani Yerima implemented Sharia in Zamfara in 1999, his approval ratings among the Zamfara electorate went vertical. He became politically untouchable overnight. Other northern governors watched that and understood the lesson immediately. Sharia implementation is the most effective political inoculation ever devised in Nigerian democracy. Think about what it does for a governor. It makes him a defender of the faith, meaning any political opposition becomes morally coded as opposition to Islam itself. It gives his poorest constituents the psychological satisfaction of visible justice. The spectacle of a flogging in a market square signals that somebody is being held accountable, even if it's never anybody powerful. And it generates zero accountability for the governor himself, because the crimes of the powerful, financial crimes, contract fraud, abuse of office, are all handled in civil courts where delay is infinite and political intervention is routine. This is a theatrical justice. It punishes visibly and cheaply. It protects the powerful invisibly and at no political cost. Now, I want to stop here and tell you something that completely reframes the political picture, because it involves the very people you'd expect to be the most vocal opponents of this system. The traditional emirate structure, the emirs, the district heads, the traditional courts have enormous informal authority in northern Nigeria. And here is what never gets said clearly enough. The emirate system and the Sharia political system have a shared interest in keeping the class filter exactly where it is. Why? Because emirate wealth is land-based, politically connected, and entirely civil in legal character. The Emir of Kano does not resolve his property dispute in a Sharia court. He does not need to. His legal affairs exist in a world of civil lawyers, federal courts, and political relationships that Sharia courts simply cannot reach. But the Emir also benefits from a population that is oriented toward religious compliance and traditional deference, a population for whom visible Sharia enforcement reinforces the idea that the system is watching, the system has standards, the system will act. That psychological environment is useful for a traditional ruling class. When the Emir of Kano, Muhammadu Sanusi II, was deposed in 2020 by Kano State Governor Abdullahi Ganduje, it was not over Sharia. It was because Sanusi had started publicly criticizing northern Nigeria's political elite for failing their own people economically. He called out the poverty. He named the failure. He was removed within weeks. The message was clear. Traditional authority is welcome when it reinforces the system. When it challenges the system, it is removed. Now, let's talk about the political economy more precisely, because the numbers tell a story that the rhetoric tries to hide. The 12 Sharia states include some of the poorest states in Nigeria by every measurable indicator. Sokoto State consistently ranks as Nigeria's poorest state. Zamfara, the state that started the Sharia movement, has per capita income figures that are devastating. Katsina, Kebbi, Yobe, these are states where poverty rates exceed 80% of the population in some surveys. Now, ask yourself, in 25 years of Sharia governance, what has changed for those people materially? The answer, measured by data, is very little. School enrollment in northern states, particularly for girls, remains the lowest in the country. Maternal mortality is catastrophically high. Infrastructure is poor. Youth unemployment is severe. But the floggings continue because the floggings are free. They cost the state nothing. They require no budget line. They require no policy competence. They are political theater produced at the cost of poor people's bodies, and they allow governors to say every election cycle that they are governing in accordance with God's law. There's a question I want to leave you with before we get to the national picture. If Sharia has failed the North economically and developmentally, why do ordinary northern Nigerians continue to support it? That answer is more complicated than either side of this debate wants to admit. I'll give you the full picture before we close.
Who are the silent players? First, Northern senators and House of Representatives members who privately acknowledge the constitutional problem with Sharia criminal law and who have never once, in 25 years of legislative sessions, introduced a bill to address it, because their constituencies would punish them for it, and their political survival matters more than constitutional clarity. Second, the Nigerian Bar Association. Lawyers know this system is constitutionally dubious. Some have written about it in journals. None have brought the landmark constitutional challenge that could force a Supreme Court ruling, because the case would require someone with standing, someone directly harmed, and the people most directly harmed are too poor, too disconnected, and too afraid to be test cases. Third, Nigerian civil society organizations that have prioritized other fights, SARS, electoral reform, fuel subsidy, and have largely left this issue untouched, partly because engaging it requires navigating religious sensitivities that make funding and coalition building difficult. The timeline of moves and counter-moves? Here it is compressed. 1999, Zamfara implements. Obasanjo protests verbally, does nothing legally. 2000, 10 more states follow. Kaduna violence kills approximately 2,000 people. 2002, Amina Lawal sentenced to death by stoning for adultery. International outcry. Case eventually overturned on evidentiary grounds. 2003 to 2015, Sharia enforcement becomes increasingly uneven, inconsistent, and class-correlated. No federal challenge. 2015 to 2023, Buhari era. Northern president. Total federal silence on Sharia constitutional status. 2023 to present, Tinubu era. Flogging videos go viral. National conversation reignites. Federal government still silent. 25 years. One consistent pattern. The poor get flogged, the powerful get civil courts. Now, if what I just laid out surprises you, drop a comment below. I want to know your take before we get to the part that changes the whole picture. Now that we've built the political picture inside the North, let's talk about what this is doing to Nigeria as a whole, because the damage is not contained to the 12 states, it is spreading, and it is structural. Let me give you 5 concrete national consequences, not abstract, not theoretical, actual measurable damage. 1. Legal citizenship is now unequal by geography and class. A Nigerian Muslim who is poor and lives in Zamfara has a fundamentally different relationship to the Nigerian state than a Nigerian Muslim who is wealthy and lives in Lagos. They carry the same green passport. They are governed by the same constitution, but one of them can be publicly flogged for behavior the other engages in freely. That is not a federation. That is a country with first and second-class citizens, and the class line is drawn by money, not faith. 2. The North's human capital crisis is being actively worsened. Every year that Sharia criminal law discourages mixed-gender public spaces, restricts entertainment industries, and creates legal uncertainty for businesses is another year that the northern Nigeria fails to develop the kind of economic ecosystem that produces jobs for young people. The North has a youth bulge, enormous numbers of young people entering the labor market. Sharia, as currently practiced, does not create jobs, it does not attract investment, it does not build the infrastructure of economic growth. It punishes poverty while doing nothing to end it. 3. Interfaith trust is being slowly, steadily eroded.
Christian communities in the Middle Belt have watched 25 years of Sharia creep, informal pressure, occasional violence, sustained legal anxiety. The low-grade, persistent sense among northern Christians that they live in states where the law does not protect them equally is not paranoia, it is rational, and it feeds cycles of communal tension that make Nigeria harder to govern and more prone to violence. 4. It is providing Boko Haram and its successors with a permanent recruitment argument. Boko Haram's founding critique, before it became what it became, was that the Sharia implemented by northern politicians was a fraud, that it punished the poor while protecting the elite, that the governors who signed Sharia bills were themselves corrupt men using Islamic language as a shield. That critique is factually accurate, and it resonates with young northern men who have been flogged, whose brothers have been flogged, who watch wealthy men walk free. The grievance is real. The extremist exploitation of that grievance is predictable. 5. It is rotting Nigeria's constitutional foundations from inside. Every year that a federal government looks at 12 states operating criminal courts that likely violate Section 10 of the Constitution and does nothing is another year that the message is sent: constitutional law in Nigeria is optional when the political cost of enforcing it is high. That lesson does not stay contained to Sharia, it spreads. It is why governors feel free to disobey court orders. It is why federal agencies operate outside their legal mandates. Constitutional abdication is contagious.
There is an international dimension to this story, and it matters for a specific reason that most coverage misses. Human Rights Watch and Amnesty International have documented Sharia flogging sentences in northern Nigeria for over 2 decades. The U.S. State Department's annual International Religious Freedom Report consistently flags the situation. The United Kingdom's Foreign, Commonwealth and Development Office has raised it in bilateral discussions. None of it has produced change, and here is why. Nigeria is too strategically important for any Western government to push this issue past the point of diplomatic discomfort. Nigeria has oil. Nigeria has 220 million people. Nigeria is a key partner in counter-terrorism across the Sahel. No American president is going to risk that relationship by publicly condemning Sharia flogging in Zamfara. The condemnations happen in reports. They do not happen in policy. But here is the international angle that actually matters and gets almost no coverage. Gulf state investment in northern Nigeria is growing. Saudi Arabia, the UAE, and Kuwait are expanding their economic footprint in the north: infrastructure, agriculture, real estate. And northern Nigerian governors have a strong political incentive to maintain an Islamic legal identity that makes them credible partners for Gulf investors. The irony? The Gulf states themselves, particularly the UAE and increasingly Saudi Arabia under Mohammed bin Salman, have been rolling back some of the most restrictive applications of Islamic law domestically. Women driving in Saudi Arabia, mixed gender concerts, entertainment industries being built. The version of Islamic governance that northern Nigerian politicians are performing is arguably more conservative than what the Gulf states themselves are currently practicing. Northern Nigerian governors are selling an image of Islamic seriousness to Gulf investors using poor Nigerians' bodies as the evidence of that seriousness. For Nigerians in the diaspora, particularly those in the UK, US, and Canada who send remittances home to northern Nigeria, understand this. The system that publicly humiliates your relatives exists partly to maintain the political optics that attract foreign money. Your community's suffering is being monetized as political credibility. Here is the statistic that stopped me cold when I found it, and I want you to sit with it for a moment before I continue. In the 12 Sharia states combined, fewer than 3% of convicted defendants in Sharia courts have had any form of legal representation. Fewer than 3%. In cases where the sentence is public flogging. In cases where the outcome is decided by a judge appointed by the governor, fewer than 3% have a lawyer. In the same states, defendants in civil courts where wealthy Nigerians resolve their disputes almost universally have legal representation.
The justice system is not blind. It is designed to see exactly who is standing in front of it and to respond accordingly. Let me deal with the arguments I know are forming in some of your minds because they deserve honest responses, not dismissal. Argument 1. You're attacking Islam. No, I am attacking a political class that is using Islamic language to protect itself from accountability. There is a fundamental difference, and the Islamic scholarly tradition itself makes that difference. The concept of adl, justice, is not peripheral to Islamic jurisprudence, it is central. A legal system that applies punishment to the poor while shielding the wealthy from the same law is not fulfilling Islamic justice, it is violating it. The scholars who designed classical Islamic law were deeply concerned with this exact problem. The Quran explicitly addresses the danger of applying law selectively based on wealth and status. Northern Nigerian scholars know this. Some say it quietly in seminars and private conversations. The ones who say it publicly tend to find their access to political patronage disappearing rapidly. Argument 2. Crime rates went down after Sharia implementation. The data on this is far more complicated than either supporters or critics acknowledge. Some categories of petty crime did show reductions in some states, particularly in the early years of implementation when enforcement was.
Let me give you what to watch for, specifically, concretely. Watch the phones. The single most disruptive force in this entire political equation is the smartphone. Flogging videos going viral is not just emotionally powerful, it is politically destabilizing in a way that printed reports and diplomatic notes never were. Every time a video circulates of a young man being flogged in a market square, a new generation of northern Nigerians sees it. Young people who are also on TikTok, who also watch Afrobeats videos, who also see how their age mates live in Lagos and London. The cognitive dissonance is building. Watch for that dissonance to become political pressure, particularly among northern urban youth. Watch the lawyers. There is a growing network of northern Nigerian human rights lawyers, young, digitally connected, many of them Muslim, who are quietly building the legal architecture for a constitutional challenge. They need a plaintiff with standing, they need a political window, they need a federal government that will not actively work against them. None of those three things have aligned yet. Watch for the moment they do. Watch the governor's children. This is the detail that is almost never discussed publicly. The children of northern governors, senior emirs, and political elites are overwhelmingly educated in private schools in Abuja, Lagos, London, and Dubai. They are not subject to Sharia courts, they do not live in the environment their fathers govern. When that generation inherits power, which is beginning to happen, watch whether they maintain the same political investment in Sharia theatrical justice or whether they quietly let it atrophy. Most likely short-term scenario, Sharia criminal enforcement continues, flogging videos continue to generate outrage cycles, and nothing structurally changes. The federal government under Tinubu, who needs northern political support for 2027, will not touch this. Best case medium-term scenario, a combination of legal challenge, civil society pressure, and shifting youth politics in the north creates enough internal pressure to force a conversation about Sharia reform, not abolition, but genuine reform that applies the law equally across class lines, that provides legal representation for defendants, that requires independent alkali appointments. That version of reform is actually consistent with classical Islamic jurisprudence. It would require political courage that has not yet appeared. Worst case scenario, the economic failure of the Sharia states deepens. Youth unemployment in the northwest reaches a crisis level. A generation of young northern men who have watched the system publicly humiliate the poor while protecting the powerful concludes that the entire system is corrupt beyond reform. The radicalization that follows does not need an organization. It just needs sufficient despair and sufficient anger. We have seen this movie before in northern Nigeria. It was called Boko Haram. The conditions that produced it have not been resolved, they have worsened. And here is the final thought I want to leave you with, because I think it reframes this entire 25-year story in one sentence. Usman Dan Fodio, the man who founded the Sokoto Caliphate in 1804, whose legacy is cited by every northern Nigerian politician who invokes Islamic governance, built his entire movement on a critique of rulers who used Islamic language to protect their own power while the poor suffered. 200 years later, the rulers of the states that sit on the soil of the Sokoto Caliphate are using Islamic language to protect their own power while the poor suffer. The man whose name they invoke would recognize exactly what they are doing. He would call it exactly what it is. We started with Usman, 22 years old, 2 bottles of beer, flogged in a market square. The man who defrauded his neighbors of their savings is still in a civil court, still waiting, still free. Here is the answer to the question I opened with. Why did only one of them bleed? Because the system was designed by people who will never bleed under it. Governors who sign Sharia bills and fly to London for medical treatment, alkalis appointed by those governors whose own families live outside the jurisdiction of the courts they run, an emirate class whose financial affairs exist entirely in the civil legal world that Sharia courts cannot reach. They built a system of visible justice for the poor and invisible impunity for themselves, and they have maintained it for 25 years because nobody with the power to challenge it has had the political will to do so. That is not Sharia. Sharia, in its classical tradition, demands equality before God's law, not a two-tier system where poverty determines your punishment. What is operating in northern Nigeria is a political machine wearing religious clothing, and the people paying the price with their bodies in public in market squares are the poorest and most vulnerable citizens in the country. The question for you is simple. Now that you see it clearly, what do you think should happen? Drop your answer in the comments, especially if you are from the north, especially if you disagree with me. This is the conversation Nigeria needs to be having, and it needs to be louder than it currently is. If this breakdown gave you clarity on what's really going on, do me a favor, share it with one person who needs to understand this. Like the video.